is taking the proceeding. I'm in transit,
Okay.
and my video just went off. So sorry about that.
Okay. Okay, Mr.
Yes.
No
Yes.
problem. Have to leave this place if you want to do that. Okay, so I'm going to proceed to read the judgment of the court. I'm reading directly from the screen. This is the judgment of the court. By an originating summons taken out by the claimant on 17th October 2024, the claimant submitted these questions to the court to determine. There are 3 questions listed, and I have read them out there. Upon the determination of the above questions, the claimant sought the following reliefs against the defendant. There are 11 reliefs, which I have also read out there. I have summarized the case of the claimant and that of the defendant, and I will go to the objections raised by the defendants first. Before I consider the originating summons, there are some issues of law raised by the defendants which need to be determined first. In the written address in support of the counter affidavit to the originating summons, the defendants raised the issues whether the claimant has the local standard to institute this action and whether the claimant disclosed the reasonable course of action against the defendants. In addition, the defendants filed 2 processes wherein they raised objection to the suit. The first one is a motion on notice filed on 15th November 2024. In this motion, the defendant sought an order of this court directing pleadings to be filed so that the substantial issues omitted by the claimant can be resolved and setting the position tested by the fire of cross-examination. The second application is a notice of preliminary objection filed on 26 November 2024, wherein the defendants prayed for an order of court dismissing the originating summons for being incompetent because the condition precedent of serving pre-action notice has not been fulfilled, and an order dismissing the suit for lack of jurisdiction on the grounds that the reliefs in the originating summons are statute barred. The grounds upon which the notice of preliminary objection is founded are this. The claimant failed to comply with the condition precedent of serving pre-action notice on the defendants before the commencement of an action, and non-compliance renders the action incompetent and robs the court of jurisdiction. According to the claimant, the reliefs contained on the face of the pre-action notice differs from those contained on the face of the originating summons, which was filed on 17th October. The second ground is that the claimant has failed to bring this action within the appropriate time stipulated by statute, being 3 months of the course from the period of the course of action, in accordance with Section 2 of the Public Officers Protection Act. From the defendant's written address in support of the counter affidavit to the originating summons, the motion and the notice of preliminary objection filed by the defendants, they have raised these points of objection. No pre-action notice was served. The suit is statute barred. The claimant lacks local standing, and the suit cannot be heard by way of originating summons. The claimant responded to the issues raised in the defendant's final written address and also opposed both applications filed by the defendants, via counter affidavits and written address. He filed which by the parties in respect of these points of objection. I will therefore proceed to determine the grounds of objection in the order I have set them out above. Now, here are the decisions on the grounds of objections. 1, non-service of pre-action notice. In paragraph 38 and 39 of the affidavit in support of the originating summons, the claimant deposed that he served the pre-action notice dated 19 June 2024 on the defendants which the defendants received on 21st June 2024. A copy of the pre-action notice was exhibited to the affidavit as Exhibit 0010. In ground 1 on the PO of the defendant's PO, the affidavit and written address in support, the defendants acknowledge that the claimant served a pre-action notice dated 19 June 2024 on the defendants, but aver that the pre-action notice is not competent on the ground that the proposed reliefs stated in the pre-action notice are different from the reliefs contained in the originating summons. Section 17 of the Companies and Allied Matters Act 2020 provides as follows. 1. A suit shall not be commenced against the Commission before the expiration of a period of 30 days after a written notice of intention to commence the suit is served upon the Commission by the intending plaintiff or his agent. 2. The notice referred to in subsection 1 shall clearly state the course of action, particulars of the claim, name and place of abode of the intending plaintiff, and the relief sought. There is no dispute that the claimant served the notice required in section 17(1) of the Act on the defendants, and 1 month had lapsed after the service before he instituted this suit. The quarrel of the defendants is with respect to the content of the notice, particularly the reliefs to be stated in it, under section 17(2)(d) of the Act. The defendant's complaint is that the reliefs stated in the notice are not the same as sought by the claimant in the originating summons. It is for this reason the defendant said the pre-action notice is not competent, and on this basis, the defendants prayed the court to dismiss this suit for being incompetent. I have examined the provisions of section 17(2)(d) of CAMA. It requires a pre-action notice to contain the reliefs of the intending claimant. I do not think the provision limits the claimant to the relief stated in the pre-action notice when filing the suit. The Supreme Court decision in Amadi versus NNPC 2000, cited by the learned senior counsel for the claimant, is apt on this point. The contents of a pre-action notice are directory statutory requirements and not mandatory requirements. Once a pre-action notice substantially complies with the requirements as to course of action, particulars of claim, name and place of abode of the intending claimant, and proposed reliefs, the provision of section 17(2) of CAMA is satisfied. The claimant is not mandated to claim the exact and every relief stated in the pre-action notice. I have seen the pre-action notice served on the defendants. It has complied with the requirements of section 17(1) and 2 of CAMA. The fact that the reliefs stated in it are slightly different from the reliefs the claimant sought in this suit does not render the pre-action notice incompetent. On the grounds whether the suit is statute barred, second grounds of the defendant's PO is that the claimant's suit is statute barred by the effect of section 2A of the Public Officers Protection Act. It was contended by the defendants that the claimant's course of action arose on 30th January 2024 when he was given his letter of promotion, but he commenced this suit on 17th October 2024, which was more than 3 months after his course of action arose. For this reason, the defendant said the claimant's suit is statute barred, having been commenced outside the time limit in section 2A of POPA. In response to this ground of objection, learned senior counsel for the claimant submitted that the provision of section 2A of POPA does not apply to cases founded on contracts, including employment contracts. Counsel relied on the Supreme Court decision in Revenue Mobilization, Allocation and Fiscal Commission versus Ajibola Johnson. I have examined the provisions of section 2A of POPA. It is to the effect that an action against a public officer must be commenced within 3 months from the date of the course of action. The implication is that where the suit is not commenced within the prescribed period, the claimant's right of action will, in respect of that cause, will be statute barred, and the court will not have jurisdiction to entertain the suit. See Ibrahim versus JSC Kaduna State 1998, Egbe versus Alhaji 1990. It is not in dispute in this suit that the defendants are public officers. It is also not in dispute that the cause of action of the claimant arose on 30th January 2024 when he received the letter of promotion. The claimant filed this suit on 17th October 2024. From the date the claimant's cause of action arose to the date he filed this suit was a period of over 8 months. It is therefore not in doubt that the claimant filed this suit against the defendants outside the 3 months period in section 2A of POPA. However, as rightly submitted by the Learned Senior Counsel for the claimant, there are established exceptions to the protection of afforded public officers in Section 2A of COPA. One of the established exceptions to Section 2A is that it does not apply to cases whose cause of action or subject matter is contracts or breaches of contract or claims for work and labor done. See Oluremi Obasanjo versus Wuraboga Nigeria Limited, 2022. Osun State Government versus Dalami, 2007. FGN versus Zebra Energy, 2002. I am not unaware of the controversies in judicial decisions as to whether POPA is applicable to contracts of employment. There have been several conflicting decisions of both the Court of Appeal and the Supreme Court on this issue. Recent decisions of the Supreme Court on this issue are those of National Revenue Mobilization Allocation and Fiscal Commission versus Ajibola Johnson, 2019, Ida Chaba versus University of Agriculture, Makurdi, 2021, Rector Kwara Polytechnic versus Adefila, 2024, Board of Directors, NIPOST, Abba versus Board of Directors, NIPOST, 2022, and Anolam versus Federal University of Technology, Owerri, 2025. While in National Revenue Mobilization Allocation and Fiscal Commission versus Ajibola Johnson and Rector Kwara Polytechnic versus Adefila, the Supreme Court decided and pronounced that the limitation period in Section 2A of COPA does not apply to cases of employment contracts. It decided otherwise in Ida Chaba versus University of Agriculture, Makurdi, Abba versus Board of Directors, NIPOST, and Anolam versus Futo, where the Apex Court held that Section 2A of COPA apply only to cases founded on contracts of employment. Now, the principle that COPA does not apply to contracts is a general and established principle. Any form of employment relationship is a contract between the employer and the employee. For this reason, there should not be any controversy as to the inapplicability of COPA to cases founded on contracts of employment, as contracts have generally been exempted from the limitation period in Section 2A of COPA. In my view, and with respect to their lordships in the Apex Court, their decisions in National Revenue Mobilization Allocation and Fiscal Commission versus Ajibola Johnson and Rector Kwara Polytechnic versus Adefila is more in tune with the established exception to the limitation period in Section 2A of COPA. I am inclined to follow these decisions. In this suit, the case of the claimant, as disclosed in the affidavits in support of the originating summons, is founded on contract of employment with the defendants. Accordingly, since the subject matter of this suit is founded on contract of service or employment, the subject matter of the suit constitutes an exception to Section 2A of COPA. In the circumstance, I hold that Section 2A of COPA does not apply to bar this suit. Accordingly, this suit is not statute barred. Having carefully considered the two grounds of the preliminary objection, I do not find any merit in them. The notice of preliminary objection is hereby dismissed. Lack of local standing and non-disclosure of reasonable cause of action. The defendants dedicated issues 1 and 2 of the written address in support of the counter affidavit to the originating summons to argue that the claimant lacks local standing to institute this suit and that the claimant did not disclose reasonable cause of action against the defendants. Upon a closer look at the reasons for the assertion, I observed that the contention is simply that the claimant is not entitled to his claims in this suit for the reason that he had resigned before the promotion. I have also heard the arguments in response made by the Learned Senior Counsel for the claimant in the claimant's reply on points of law. The term local standing means the right of a party to institute an action and to appear in court and be heard on the questions he brought before the court. A party who brings an action before the court must disclose sufficient interest in the subject matter of the suit or in the outcome of the suit, or must show that he will suffer or stand to suffer an injury either by the enforcement or threatened exercise of some power, authority, or right which he complained about in the suit. These are the facts which indicate that the party who institutes the suit has local standing in the suit. In DOPA versus Registered Trustees, UMCN 2019, it was held that local standing means the legal capacity or standing of a party to institute an action in a competent court of law or tribunal. Therefore, the challenge of a person's local standing in a case raises a question of whether the person whose standing is in issue is the proper person to seek the adjudication of the court or tribunal upon the issues involved in or in the subject matter of the case. See also East Horizon Gas Company Limited versus FYOC 2012, Adetono versus Zenith International Bank PLC 2012. The claimant's case is that he took part in the first defendant's promotion exercise before he resigned in December 2022, and in January 2024, he received a promotion letter informing him that he had been promoted from principal manager on CAS 4/6 to assistant director on CAS 3/3. With effect from 1st January 2022, following the conclusion of the 2021 promotion exercise. It was for this reason the claimant has brought this suit for the court to determine whether he is entitled to payment of salary arrears and balance of gratuity and pension due to him upon his promotion to assistant director from 1st January 2022 to 20th December 2022. In view of the facts of the case of the claimant, he has disclosed sufficient local standing to enable him institute and maintain the suit. By the facts in the affidavit in support of the originating summons, the claimant has also disclosed course of action against the defendant. I have seen that the contention of the learned senior counsel for the defendants for challenging the local standing of the claimant and for alleging non-disclosure of reasonable course of action are matters which involve the merits of the claimant's case. At this point, I am satisfied that the claimant has disclosed his local standing and a reasonable course of action against the defendants. The merits of his case will be determined when I get to that stage. Non-suitability of originating summons to determine this suit. In the defendant's motion of 15th November 2024, they want this court to direct that pleadings be filed. In other words, the defendants are saying that this suit cannot be properly determined by way of originating summons. This was what was insinuated in the affidavit in some support of the motion and in the written address. I do not agree with the defendants. The issue involved or to be determined in this case is narrow, simple, and straightforward. The issue can be resolved through the affidavit evidence of the parties. Accordingly, I hold that the suit instituted via originating summons is proper, and I shall determine the suit in that manner. The motion filed by the defendants on 15 November 2024 lacks merit, and it is hereby dismissed. Now to the decision on the originating summons. The claimant submitted 3 questions for determination in the originating summons, but on close examination of the questions, it is observed that the resolution of question 1 will determine all issues in this matter. Accordingly, question 1 constitutes the sole issue I will determine in this originating summons. The facts of this case are that as at December 2022, the claimant held the position of principal manager on grade level CAS 04/3 in the service of the first defendant. He resigned his appointment on 20th December 2022, paid 3 months basic salary in lieu of notice to the first defendant, and he was subsequently paid his terminal benefits computed on the basis of his grade level at the time of his resignation. Before he resigned, the claimant took part in some aspects of the first defendant's 2021 staff promotion exercise, except the oral interview, which had not been conducted before the claimant resigned from the first defendant's employment on 20th December 2022. By implication, the promotion exercise had not been concluded before the claimant resigned from the employment. In an internal memo of the first defendant dated 12 January 2024, the first defendant invited qualified staff for the promotion oral interview, which held on 17th and 18th January 2024. The claimant said he was also invited for the oral interview. He attended and was interviewed. By a letter dated 30th January 2024, which was a period of about 13 months after the claimant had resigned his appointment with the first defendant, the claimant was in to assistant director on CAS 3/3 with effect from 1st January 2022, following the conclusion of the 2021 promotion exercise. When the claimant received the promotion letter, he started to demand from the first defendant that he should be paid arrears of his salary gratuity, and pension due to him as Assistant Director on CAS 33 from the effective date of the promotion, being 1st January 2022, to the time he resigned on 20 December 2022. When the defendants refused his request, he brought this suit for the court to determine basically whether by virtue of the letter of promotion he is entitled to payment of salary arrears and balance of gratuity and pension due to him upon his promotion to Assistant Director in CAS 33 from 1st January 2022 to 20 December 2022. The defendants did not dispute the fact that the claimant resigned his appointment in December 2022, and they admitted that the claimant attended the oral interview of January 2024, but said the claimant did so fraudulently as he was not invited for the interview, having exited the employment. They also stated that the claimant was issued the promotion letter of 30 January 2024, but averred that the claimant was no longer a staff of the first defendant in 2024 when the promotion was effected. As such, the claimant is not entitled to be paid arrears of salary. I have read the submissions made by the learned senior counsels for the parties in the respective written addresses and the authorities cited therein. I intend to keep my decision on the issue in this originating summons precise and simple. Now, the claimant wants this court to construe the letter of promotion, Section 12 of the Companies and Allied Matters Act 2020, Articles 11.07 and 11.09 of Chapter 11 of the Conditions of Service of First Defendant, and the Circular on Cancellation of Policy on Granting Notional Promotion in the Public Service dated 28 May 2010, in order to determine the issue for determination in the originating summons. The letter of promotion is Exhibit 005. The condition of service of the first defendant is Exhibit 001, while the Circular of Cancellation of Policy on Granting Notional Promotion in the Public Service is Exhibit 0011. The claimant also exhibited the public service rules. It is Exhibit 006. The letter of promotion reads as follows. HR/Con 1585, January 30, 2024. Ologe Olumide Abayomi, UFS, Director, Compliance and Litigation Department, Corporate Affairs Commission, Abuja. Letter of promotion. I'm pleased to inform you that following the concluded 2021 appraisal exercise, the Honorable Minister of Industry, Trade and Investment has approved your promotion from Principal Manager on CAS 4/6 to Assistant Director on CAS 3/3 with effect from 1st January 2022. It is hoped that you will reflect this positive development in your output and commitment to duty. Signed, Hussaini Ishaq Magaji, SAN, Registrar General. This letter is straight to the point. In the letter, which is dated 30 January 2024, the claimant was informed that approval had been given for his promotion from Principal Manager to Assistant Director with effect from 1st January 2022 in respect of the concluded 2021 promotion exercise. Section 12 of the Companies and Allied Matters Act provides as follows. 1. Service in the Commission shall be approved service for the purpose of the Pension Reform Act or any amendment thereto or reenactment thereof, and accordingly, officers and other persons employed in the Commission are, in respect of their service in the Commission, entitled to pensions, gratuities, and other retirement benefits as determined in the Commission's condition of service. 2. Nothing in this act shall prevent the appointment of a person to any office on terms in the Commission which preclude the grant of pension contributions or gratuity. While Article 11.07 and 11.09 of Chapter 11 of the Condition of Service of the First Defendants provides as follows. 11.07 Retirement Benefit Scheme. The Commission shall establish compulsory pension scheme for the payment of retirement benefits of its employees. The Commission shall contribute 7.5%, while the staff shall contribute 5% of annual gross salary. Gratuity. 11.09 Gratuity. Staff shall receive tax-free lump sum gratuity on retirement in accordance with the following schedule. Completed years of service, 5 years. completed years of service stroke proportion of benefit. 5 years, 75%, 6 years, 100%, 7 years, 125%, 8 years, 150%, 9 years, 175%, 10 years, 200%, 11 years, but less than 15 years, 225%. 15, but not less than 20 years, 250%. 20, but not less than 30 years, 275%. 30 years and above, 300%. The content of the circular on cancellation of policy of granting notional promotion in the public service is as follows. Circular, review cancellation of policy on granting of notional promotion. Further to the Commission Circular of 2nd July 2003 on review of the policy on notional promotion to entitled officers of the Federal Civil Service. I am directed to inform you that the Commission has decided to put an end to the issue of notional promotion with effect 1st January 2011. Consequently, no recommendation for notional promotion will be considered with effect from that day. All MDAs that are in arrears of promotion are hereby directed to conduct promotion interviews and process all senior staff committee recommendations on promotion to the Commission on or before 30th November 2010. For the avoidance of doubt, any MDA that fails to conclude its promotion before the above deadline will be held responsible for the non-promotion of staff and will be accordingly sanctioned. Permanent secretaries and heads of extra-ministerial departments are advised to ensure strict compliance with this circular, please. The peculiar issue to be determined here is whether the claimant, having exited from the employment of the first defendant 13 months before his promotion to the position of assistant director was approved, whether he is entitled to be paid salary for the position of assistant director which he was promoted to, and his gratuity and pension recomputed using the new position of assistant director. Both Section 12 of the Companies and Allied Matters Act and Articles 11.07 and 09 of Chapter 11 of the Condition of Service provide that staff are entitled to pension and gratuity by the provisions of Article 11.07 and 09. What is contemplated in the payment of gratuity and pension is the amount contributed using the employee's annual gross salary and the number of years served in the employment. The provision of Section 12 of CAMA and Article 11.07 and 11.09 of Chapter 11 of the Condition of Service, which the claimants want me to consider to determine the issue in the originating summons, have not directly answered the question. With respect to the circular on cancellation policy on granting notional promotion, its purpose is to prohibit notional promotion, and it applies to subsisting employments in the civil service. Notional promotion, which was abolished by the circular, is with respect to officers who are in service and entitled to take part in the promotion exercise. There's nothing in the circular suggesting that an employee who has resigned from the employment is entitled to notional promotion and payment of arrears of salary accruing on the promotion. The circular, in my view, has not addressed the issue in this case. Upon examining the provisions of Section 12 of the Companies and Allied Matters Act 2020, Articles 11.07 and 09 of Chapter 11 of Condition of Service of First Defendants, and the circular on cancellation of policy of cancellation of policy on granting notional promotion in the public service, I find that the provisions are not relevant to the peculiar situation in this case. It is not in dispute that the claimant participated in the First Defendant 2021 staff promotion exam, but promotion exercise, but it was not concluded before he resigned his appointment from the service of the First Defendant on 20th December 2022. At the time the claimant resigned, his position was principal manager, and he resigned from the employment in that position. The claimant said he paid 3 months' salary in lieu of notice. That is to say, the salary he paid in lieu of notice was the salary he was earning for the position of principal manager. The claimant's terminal benefits and pension were also computed as at the time of his resignation and paid to him. Thus, effective from 20th December 2022, the claimant ceased to be an employee of the First Defendant. It is the law that tendering a letter of resignation by an employee effectively and automatically puts an end to the employment on the date indicated in the resignation letter, and the employee can no longer be subject to the terms and conditions of the employment, including control by the employer or enjoyment of privileges or rights available in the employment. See WAEC versus Oshonebo 2006, Adefemi versus Abegunde 2004. Once tendered by the employee, a resignation letter puts an end to the employment contract, such that the terms and conditions of service will no longer be applicable to the employee, and no disciplinary action can be taken against the employee for any action or conduct done by him while still in the employment. See Abeke versus Alpha Merchant Bank PLC 2017. What this means is that an employee who resigned from an employment is no longer bound by the terms and conditions of the employment. Thus, from 20th December 2022, when the claimant's resignation became effective, he no longer had any contract of employment with the first defendant, and not being a member of staff to whom the condition of service of the first defendant was applicable, the claimant cannot render any services to the first defendant. He cannot participate in any staff activities of the first defendant, and he cannot enjoy any of the privileges and benefits provided for staff of the first defendant under the condition of service. Accordingly, the claimant was not entitled to participate in the promotion oral interview in January 2024, which was the concluding part of the promotion exercise, or be promoted at all after he had ceased to be an employee of the first defendant since December 2022. The claimant knew he was no longer a staff of the first defendant as of January 2024 by his own act of resignation. He had no reason to have attended the oral interview, which took place 13 months after he had left the employment. If he was indeed invited for the oral interview, it was clearly a blunder on the part of the defendants. But the blunder does not have the effect of reviving the terminated employment contract. The claimant, even though took part in some aspects of the promotion exercise while he was in the employment, he forfeited his participation in the promotion exam when he resigned before the oral interview or conclusion of the promotion exercise. As at the date of the oral interview and the approval of the promotion, no contract of employment existed between him and the first defendant to entitle him to attend the oral interview or be given the promotion. His participation in the promotion exercise went away with his resignation. When he decided to partake in the oral interview, despite having full knowledge that he was no longer an employee of the first defendant, it was an exercise in futility. The claimant did not complete the 2021 promotion process when he was still a staff of the first defendant. Having resigned before the process was completed, he is therefore not qualified or entitled for promotion in that exercise. In my view, the claimant does not deserve the promotion in the first place, having not completed the promotion process before he resigned. In addition, the claimant had resigned before the promotion was approved. He never rendered any service to the first defendant in the new position. It would have been a different thing if the claimant was still in the employment as at the date of the promotion letter. In that instance, his promotion would have been taken from the date indicated in the letter, and he would have been entitled to all benefits accruing to the new position. In this case, where he had resigned before the promotion was approved, the claimant cannot claim for salary or benefits from the employment that had ceased to exist. Let me add that the promotion letter appears to me to have been written to the claimant in error. The promotion letter was addressed to the claimant in the department he was at the time of his resignation in December 2022. The letter also contains that the first defendant expected more output from the claimant in the discharge of his duties in the new position. From the content of the letter, it is clear that the defendants acted under the mistaken belief that the claimant was still in their employment. That was why the defendants still expected him to be committed to his duties in his new position. In sum, it is my view that the claimant was not entitled to the promotion communicated to him in the letter dated 30th January 2024. Accordingly, the claimant cannot make any claim on the defendants on the basis of the said letter. I resolve question 1 in the originating summons in the negative and against the claimant. The same decision applies to questions 2 and 3. The result is that I find no merit in the claims sought by the claimant. This suit is dismissed. Okay,
Uh,
so that's it. The
my
judgment
lord,
has been delivered.
my apologies that my
Yes,
mistake cannot come on. At this stage, I think it is just fair that I at least make a
yes,
comment. I'm so sorry that the video is not coming up. My lord, we
yes,
thank
it's
the
fine.
court. We thank the court. The best we can do as counsel is to bring what would appear to be our position, our thinking is seeking the court interpretation before the court. And whatever we say or argue is always subject to the overriding position of the court and decision of the
Yes,
court. And no doubt, my Lord has been thorough in the analysis of all the issues that arose. And we
thank
thank the
you.
court and we're most grateful. Thank you so much.
Thank you. Thank you very much. So I
My
will
lord,
make copies available as before the end of today or tomorrow latest. Is anybody here to announce appearance for the
yes, my
defendant?
noble lord. Yes, my noble
Yes,
lord.
the
May my
name?
noble lord be pleased.
Yes.
C.N. Ayo for the defendants.
Thank you.
Thank you, my noble lord.
Thank you very much, everyone. Have a very good evening.
You too,
Yes,
my
ma'am.
lord.
Yes.
Thank you.
You're most welcome.
Thank you.